Hello everyone, welcome to our talk today. I am Mang Cai, PhD, JD, attorney at law at New Weiming Law Group. Our contact information is available on this video. So today, my topic is 7 frequently asked questions regarding family-based immigration. As we know, the US is a nation of immigrants. Each year, more than 1 million foreigners receive US permanent residency or green cards. And among them, the vast majority are family-based immigrants. So today, let's talk about frequently asked questions on family-based immigration. First question is, who are eligible for family-based immigration? Well, there are 2 major categories. First, there are so-called immediate relatives of US citizens, including their spouses, parents, and young children under 21. There is no quota limit and no waiting time. Other than those, there are also other 4 categories. First preference is the unmarried sons and daughters of US citizens. So here, those sons and daughters of US citizens are older than 21. For example, if for whatever reason you obtain US citizenship and have foreign-born sons or daughters who are already more than 21 years old, they can get family-based immigration through this category. And then the second preference, there are 2 subcategories. First is spouses and children of US permanent residents or green card holders. This accounts for a large number of family-based immigrants. So for example, if you marry someone who already has US green card, and that person can apply US immigration for you to get your green card. And as we will see later, the process itself actually does not take much time. And another subcategory here in the second preference is unmarried sons and daughters of permanent residents. Again, here for the sons and daughters, we mean those who are older than 21 years old. The third preference is married sons and daughters of US citizens. The fourth preference is brothers and sisters of adult US citizens. So that's the first frequently asked question. Second frequently asked question is, what application forms are required for family-based immigration? Well, for the petitioner, either the US citizen or the green card holder, the petitioner will need to submit I-130 form. And then if the beneficiary is already in the US, he or she will need to submit I-485 adjustment of status application form. If the beneficiary is currently outside of the US, then he or she can use the consular processing to get immigrant visa in US embassy or consulate abroad. The next question, what additional forms and documents are required for the family-based immigration? Well, usually, the petitioner will also need to submit I-864 form for the financial support to show the petitioner has sufficient income or asset to support the life of the incoming immigrant in the US, so that the incoming immigrant will not be a public charge of the US society. And of course, in addition, there needs to be supporting materials to prove the income and assets, such as pay stub, W-2 form, tax forms. Other than that, we will need documents to establish the family relationship. The next question, what factors are important in determining whether the family-based immigration petition is approved or not? Well, as we mentioned, we need to demonstrate the family relationship. For example, if someone, either a US citizen or a US permanent resident, applies for his or her spouse, the petitioner will need to show the bona fide marriage relationship. For example, joint ownership of bank accounts, house, or joint insurance policy, or other proof of their relationship. And other than that, there needs to be financial support. If the petitioner does not have sufficient income or asset, there can be joint sponsor to help with the financial support. On top of that, there also needs to be evidence that the beneficiary has a satisfactory past immigration history. For example, the beneficiary did not enter the US illegally, did not have long-term violation of the US immigration law. So again, the beneficiary's past immigration history is also important. The next question, how long it may take for the family-based immigration process? Again, it depends on which immigration category. Well, what is the family relationship and who is the petitioner? Whether the petitioner is a US citizen or a permanent resident. For example, one important difference is a US citizen can apply green cards for his or her parents, and there's no waiting time. On the other hand, permanent resident US green card holders cannot apply green cards for their parents. As we know, the immediate relatives, like the spouse, children, and the parents of US citizens, there is no waiting time. The I-130 and the adjustment of status 485 can be submitted concurrently. If the beneficiary is abroad, then the I-130 needs to be submitted and approved first. Then the consular process can start. That may take 6 months or so for the beneficiary to get immigrant visa, then to come to the US to receive his or her green card. What about other relatives and other petitioners? For the first preference, unmarried sons and daughters of US citizens older than 21. Well, the current cutoff date is March 2012. Those who filed application for their relatives before March 2012, now the beneficiary may apply 485 or consular processing. For the second preference, the F2A, spouse and children of US permanent residents, the green card holder, the cutoff date actually is pretty close to present time. It's December 2017. In other words, well, if you married a US green card holder, say in November 2017, and then your spouse, the green card holder, submitted I-130 immediately after that, before December 2017, the application, whether it's pending or already approved, now if you are in the US, you can submit I-485 adjustment of status application. And what about F2B, the unmarried sons and daughters older than 21 of US permanent residents? For them, the cutoff date currently is January 2012. The third preference, married sons and daughters of US citizens, the cutoff date is September 2006. So you see it's a long wait, more than 10 years. And the fourth preference, brothers and sisters of adult US citizens. The waiting time is even longer. It's May 2005. But as you know, many other countries of immigrants, like Canada or Australia, they do not even have such kind of family-based immigration category that allows their citizens to apply for their siblings directly. Then the next frequently asked question, will there be interview before the application is approved? The answer is yes. Well, whether you apply 485 adjustment of status inside the US or you apply through the consular processing, there will be interview process. And if you do not speak English, well, you can have a translator, interpreter to accompany you to the interview. Well, if you are applying based on marriage, it is better for your spouse also attend the interview to prove the bona fide marriage relationship and help answer questions regarding the marriage relationship. It is preferable to have an attorney to accompany you to the interview to help answer the questions from the immigration officers. Finally, the last question, how can I get more information regarding family-based immigration? Well, you can contact us, New Weiming Law Group, check our website, and send us an email. We have abundant experience in handling this kind of application, and we have obtained approvals for many cases. In addition, multiple co-workers in our law firm have personal experience of getting their own US green cards through the family-based immigration. Okay, that's all for now. Thank you.